Commissioner Fielder, can you hear us?
Yes, I can. Thank you.
Okay, thank you. Mr. Jetty? All right. Time is now 1 p.m. We're going to go back on the record. We are at the hearing on the application of DI Garbage Disposal of Bozeman LLC, doing business as Redbox Plus of Bozeman. This is docket number 2021.03.043. Before I move to the protestant, Mr. Jetty, are there any motions you would like to make at this point in time? If not, I will move to.
No, Your Honor. Go ahead.
Okay. All right. Mr. Mercer, this is the time for your case in chief, but I understand that you would like to make a motion.
Thank you, Mr. Chairman. And as I indicated before we took the break, we think a directed verdict motion is in order given the state of the proof at the close of the applicant's case. And I just want to focus initially on fitness. There is absolutely nothing that the applicant has provided to the commission that allows the commission to conclude that this is a fit applicant. And I think as the commission has considered these cases over the years in the past, one of the key considerations is if you give the applicant the license, are they going to have the ability to render the services that they have applied for? And the test that you're going to look at there is going to include things like, do they have the requisite capitalization? Do they have the experience where if we give them this ticket, they are going to be able to reliably serve customers? What are their staffing plans? Do they have the financial resources to deliver whatever it is that they profess to say they're going to deliver? And admittedly, they say in their application they only want to provide minimal roll-offs, which begs a whole nother set of questions, which is how are they going to serve all points and places in these three counties? But on fitness alone, the commission has nothing to rely upon in terms of making a determination that this applicant meets that test. So we believe that the directed verdict is appropriate with respect to fitness. On need, the proof at this point, and given that the case is closed, we have 3 shipper witnesses, 2 of whom we think we've established have direct relationships with the Dairyfield Investments, which is the company that this couple who's applying own. And so the last 2 witnesses we've heard from are affiliated with Dairyfield. They're not shipper witnesses who are coming to you objectively and saying, this is what we've seen in the market. These are people who want to have this go forward. I think Mr. Thorson specifically said he had an interest that was going to be advanced here. And so you're left with a record where the proof you have first is only 3 people. There was never any conversation about Park. There was never any conversation about Madison County. We have 3 witnesses who spoke of their perceptions about the level of service and the need in Gallatin County. And only one of those individuals is someone who doesn't have a vested interest in the outcome. So on need, the idea that there is something that meets the test that would give the commission the proof to say, yes, there is a public need that is unmet. There just isn't anything in our view that you can hang your hat on with respect to that question at this stage in the case. So we don't believe it's appropriate to move to the next stage where we would call witnesses because we don't think that they've met their prima facie burden. And so we think that you have the inherent authority based upon the proof to say that this case should not go forward at this stage. The application should be denied. And thank you, Mr. Chairman.
Mr. Jettie, would you like to respond?
Yes, Mr. Chairman, thank you. Mr. Chairman, members of the committee, I draw your attention to the administrative rule of Montana 38.3.406 subsection 2B that says a protester will not be successful unless they provide compelling evidence that the applicant is not fit, willing, and able to perform. So simply by objecting to the evidence that we were prepared to offer into evidence that shows that they are fit, willing, and able to provide these services doesn't meet that burden. If they haven't presented any evidence to prove contrary, just simply sitting back and objecting to our evidence doesn't meet that burden.
Mr. Mercer, how do you?
Thank you, Mr. Chairman. The idea that somehow the protestant has to prove that the applicant isn't fit would turn the test completely on its head. It's the applicant's burden to demonstrate that there is a public need that's being unmet, that it can't be met by current carriers, that this is a carrier that is fit to do that in the first instance. That is not a burden that is somehow shifted to the protestant to disprove. The applicant has to do that in the first instance.
All right. Thank you, counsel, for argument. So, commissioners, you have before you a motion for a directed verdict. In this case, this is what's known in the law as a dispositive motion. That means that if the commission votes to grant this motion, that will dispose of this proceeding. And therefore, this requires, in my opinion, a full commission vote. And so at this point in time, I would entertain a motion from Vice Chair Johnson.
Thank you, Mr. Chairman. Mr. Chairman, I move to grant Republic's motion for directed verdict. Though I want to make clear, this is only to deal with the first prong of the Commission's PNC test regarding the applicant's fitness. And accordingly, we should dismiss this application without prejudice to Redbox+'s ability to file a new application. We just have not had any witnesses from Redbox, either corporate or the assumed franchisee, nor any introduction of documentary evidence in support of fitness. And without any of those witnesses or that evidence, I don't believe Redbox has met its burden of proof with regard to the first prong of the test in terms of fitness to become an authorized operator under our Class D rules, Mr. Chairman.
Thank you, Mr. Vice Chair. Is there a second? Commissioner Pinocci has seconded. Discussion.
Mr. Chairman.
Commissioner. Yes, Commissioner Fielder.
Thank you, Mr. Chairman. I'd just like confirmation from staff on that rule that was recited to us on regarding the point of who has the burden of proof regarding fitness.
Mr. Ogala.
Yeah, Chair Brown, Commissioner Fielder. I disagree respectfully with Redbox. They cited to 38.3.406. And that applies to certificates of compliance. And our operative structure here is the PCNN license. And so that's 38.3.405. There is healthy room for discussion on where the burden lies in the 4-part PCNN test that's not established in regulation. But I think what is clear from my read of our prior cases is that it is the applicant's burden to establish both fitness and need for services, the first 2 prongs.
Okay, thank
Follow-up,
you.
Commissioner Fielder.
Mr. Chairman, just
Go
to
ahead.
comment on the discussion. It's unfortunate that we cannot make a determination. I feel we cannot make a determination based on actual evidence today. That evidence obviously was not provided timely by the applicant, and when they attempted to provide it later, it was objected to by the protester. So we have before us, I don't see that we have much of a choice today other than to rule in favor of the motion. Unfortunately, I do not feel that this process today has been based on justice. I feel it's been mired in procedure. And I would hope that the applicant could address those procedures and perhaps come back and allow us to hear this case based on sufficient information, because right now I feel we have insufficient information.
Thank you, Commissioner Fielder. Additional discussion? Commissioner O'Donnell?
Thank you, Mr. Chairman. It seems to me that the public interest that the state has given to us is to protect the public in this. It's not meant to protect any incumbent monopoly in a protected territory, but to make sure that unqualified people, clearly unqualified people, are not allowed entry into it until they can demonstrate. So I have a difficulty with the word prove their fitness, but I think because how much financing is necessary to run a business? Well, that's quite a bit subjectivity, and it's hard for us to determine that. But I quite agree that unfortunately we don't have enough of the information available to us right now, and I look forward to looking at this thing again in the future, because it's, in my mind, it's not between party A and party B here. Is that we are here to make sure that the public is served, and I think the public has been left out of this, and I want to thoroughly engage in discovery and discussion on this issue. So thank you, Mr. Chairman.
Thank you, Commissioner O'Donnell. Additional discussion? Mr. Vice Chair.
Thank you, Mr. Chairman. And I wasn't going to say anything further, but I just want to make clear that it is not inherent in my motion, Mr. Chairman, that we find the applicant unfit. That is not what we're saying here. We're saying that they failed to meet the burden of proof to suggest that, in fact, they are fit. And I think with regard to Mr. Jetty's argument, it's pretty tough for a protestant to disprove something that hasn't been established in the record, Mr. Chairman.
Thank you, Mr. Vice Chair. Additional discussion? So I will comment on this. I'm going to support this motion. I'm of the firm belief that the legislature has made it clear that under the statute, it is the applicant's burden to prove that they're entitled, if you will, to a Class D PCN certificate. I may have some philosophical differences, perhaps, with what the legislature has done here, but I am an attorney and I will follow what the legislature tells us to do as regulators, and I believe the legislature is clear as to what needs to be satisfied in terms of obtaining a Class D PCN certificate. At the same time, I think under the statutory scheme that has been set forth by the legislature, this type of case is not generally conducive to motions of this kind. And I'm therefore a reticent supporter of the vice chair's motion. But in this particular instance, there is a paucity, if you will, of evidence that has been presented by the applicant at this point on the first two prongs of the Class D test, if you will, fitness and need. As to the underlying motion, I don't believe any written briefing is required to resolve this issue. The parties do have the right to provide oral argument or briefing on all motions in commission proceedings. Here, the parties provided oral argument on the directed verdict, which satisfies Montana Administrative Rule 38.2.4502. I would also note for future proceedings, because I don't believe this motion and our ruling on it will be precedential. As I stated, the history of the PSC, if you look back, we don't really entertain motions for a directed verdict. We have neither adopted the rule for a directed verdict in commission regulation, nor have we created a similar ability to move for judgment as a matter of law. However, the commission has broad powers to rule on evidentiary and dispositive motions during the course of proceedings, which includes the ability to entertain motions for a directed verdict, in my opinion. Again, though, this is not precedential because of the unique facts and circumstances of this case. I'm going to vote for the directed verdict. I would just note, as the vice chair correctly pointed out, that Redbox can reapply for a Class D license in the future. That is contemplated by our statutory scheme. This motion, as the vice chair pointed out, contemplates a directed verdict if passed without prejudice. So as noted, Redbox can come back to the commission at some point and refile with the new application for a Class D license. Additional discussion? Commissioner Panochi.
Looking out for thank you, Mr. Chairman, the ratepayer might have a couple of concerns where people that gave testimony might have been connected to Redbox. And I would think a ratepayer would be concerned about that. Also, if you're not able to get your paperwork filed in a timely fashion or correctly, the ratepayer may think, what chance is that provider showing us that they'll do a good job if they do the job? So I think that the ratepayer might be asking to bring those 2 points up today at this hearing. Also, I think the ratepayer would have liked to have heard competition is good because it gives people a choice. And I was surprised that I didn't hear that testimony from somebody who didn't have any connection with anybody, simply saying choice usually is a win for the ratepayer. And I was surprised I didn't hear that today. And of course, a new company is going to have brightly painted trucks and containers. We all know that Bozeman is different than other towns and have different requirements on how business conducts itself. Walmart, for instance, had to be quite fancier than any other Walmart in the state. Perhaps all the garbage trucks need to be repainted. Anyway, those are some points I thought the ratepayer might want me to bring out today. Thank you, Mr. Chairman.
Okay, seeing no further discussion or comment, all those in favor of, we'll do a roll call on this. All those in favor of Vice Chair Johnson's motion to grant the motion for directed verdict filed by the protestant in this manner. Vice Chair Johnson?
Aye.
Commissioner O'Donnell?
Aye.
Commissioner Panochi?
Aye.
Commissioner Fielder?
Aye.
And I will vote aye as well. The motion for directed verdict is granted. So that will end today's proceedings. Thank you both for your presentation today. We appreciate your time, and my thanks to those shipper witnesses that took time out of their busy schedule to participate today. So this evidentiary hearing now comes to a close, and remarkably, I have to reopen for public comment on this matter. And Mr. Hamilton, do we have any public comment? Sure. If anybody that's on the line at this point would like to make public comment at this point in time, please feel free to do so. As noted, today's matter has concluded as a matter of law, but you can certainly weigh in if you'd like. You can go ahead and unmute yourself if you'd like to be recognized. *6 often works. Mr. Regala, do you see any requests? Mr. Hamilton, do you see any requests? Okay. At this point in time, I see no need to do a scheduling conference as we have disposed of this matter on the merits. And with that said, it is now 1:20 p.m. and we are closed.